can't stop those things from happening. And so this song was basically like, is it enough? Is the stuff that I can control enough?
Unfortunately, Taylor Swift is in real trouble this time. Though giving a back-to-back hit, the singer has not yet celebrated her song's success. Speaking of this issue, Taylor Swift is accused of allegedly copying or plagiarizing lyrics in her hit song Shake It Off from the song Playas Gon by the R&B trio 3LW. Recently on Thursday, a federal judge dismissed Taylor Swift's request to dismiss a copyright infringement lawsuit that accused her of stealing lyrics from the 2014 hit song Shake It Off and ordered the case to go to trial. It can be surely said that Taylor does not want that to happen, and it is better for her and the team if the case gets dismissed, but the federal judge has different plans. Well, if we look at the case from a practical point of view, what the court decided totally makes sense, as both the parties should get their equal say. Like how Taylor wants the case to get dismissed, the other party wishes to win, hence there's no controversy should be made with it. To be precise, the lawsuit was filed by Sean Hall and Nathan Butler, the authors of the 2001 song Playas Gon by R&B group 3LW. Well, only if Sean was Taylor's friend, the case would have never registered. This is why people say, make the connection unlucky for both of them. Continuing about the case, an experiment will test whether parts of Miss Swift's song, including versions of the phrases players going play and haters going hate, and are sufficiently similar to previous songs, and following the investigation, the courtroom will also see if the lyrics meet the legal threshold for copyright infringement. The judge in charge of United States District Court for the Central District of California, Judge Michael Fitzgerald, this week on Thursday rejected Ms. Taylor Swift's request for summary judgment. The courtroom has come to a point concluding that unless and until a settlement is reached, the case will enter the trial stage. Well, it is gonna be a long journey for Taylor and the accusers, Sean Hall and Nathan Butler, the authors of the 2001 song Playas Gon. Explaining more about what happened in the courtroom, in the ruling, Judge Fitzgerald of United States District Court for the Central District of California stated that Ms. Taylor Swift's legal team made a strong closing statement, but failed to verify that the jury was unable to resolve the issues in the case. On the other hand, additional defendants in the case include producers Max Martin and Shellback, who are music publishers Sony and Cobalt, the HBO Group, and Universal Music Group. Of course, Taylor has got a strong team. However, as a matter of fact, the lawyers' team for Ms. Taylor Swift and the other defendants did not immediately respond to requests for comment on Friday. They are holding it for God knows what reason, but some statements are released in the same relation. As a result, Ms. Taylor Swift's lawyer Marina Bogorad wrote in an email, "Our clients are very satisfied with this decision, especially because it reinforces the notion that they are based on a deeply rooted, the unique self-expression of cultural heritage cannot be simply taken away without proper attribution." Looking back in the past, the songwriters Sean Hall and Nathan Butler, the authors of the 2001 song Playas Gon by R&B group 3LW, first filed a lawsuit against Taylor Swift in September 2017. As discussed, Judge Fitzgerald dismissed the case in 2018, but the U.S. Court of Appeals for the Ninth Circuit returned it to the court. Whereas the lyrics under consideration in Miss Swift's song read, "'Cause the player's gonna play, 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 play," and the haters gonna hate, 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 hate. And to differentiate, these lines are being tested against playas they gon' play and haters they gonna hate, from the song by 3LW, an all-female R&B trio popular in the early 2000s. Precisely, the judge made her statement and said in the original ruling in 2018 that the lyrics in the debate were too short, unoriginal, and lacking in creativity to be protected by the copyright law. In the early 2000s, popular culture was adequately suffused with the concepts of players and haters to render the phrases playas gonna play or haters gonna hate, standing on their own, no more creative than runners gonna run, drummers gonna drum, or swimmers gonna swim, he noted in his February 2018 order. In addition, George Howard, a professor of music business management at the Berklee Conservatory of Music, represented the system for testing music copyrights as insufficient and imperfect. Continuing, he said that in many cases, record companies and publishers will settle if they think they might lose the case. For a fact, Sir George Howard's point does make sense if you understand his saying practically. because this is what people actually do to get rid of something that affects and hinders their work or whatever. Whereas in recent years, many high-profile cases have tested music copyright standards in court. However, it is also considered that in some cases, people worry that artists will face a large number of lawsuits. After the federal jury concluded that Robin Thicke's 2013 song Fuzzy Lines copied Marvin Gaye's Must Give Up elements, musicians and record business forewarned that this precedent might have a chilling effect on artists. But later in 2020, precisely after Led Zeppelin won the copyright lawsuit in October of that year, some people believed that the trend was changing. A few months ago, a federal judge reversed an earlier ruling that Katy Perry's popular song Dark Horse violated the copyright of Christian rap songs. This was all about it. Thank you for watching the video. If you enjoyed it, please like it and subscribe to the channel Peeper. Please let us know your thoughts in the comment section.